Do you know that, Alicia? Yeah. All right, people are still coming in, but I think we're going to get started because I'm concerned we have an ambitious program on tap, and I don't want to run out of time.
We just get talking about mediation.
So, we're still waiting for one of our speakers, Judge Grappio, but knowing Judge Grappio, she is definitely on her way, so we're going to get started. First, I would ask all of you to please turn off your cell phones.
Oh, yes.
And good afternoon. On behalf of the 3rd Judicial District Gender Fairness Committee, I'd like to welcome you to this program. I'm Rachel Kretzer, chair of the committee, and I would like to begin by asking our hardworking committee members who are here today to please stand and be recognized, because obviously we couldn't do it without the committee. Come on, don't be shy. Where's Judge Riley? Yeah, okay. So, Judge Breslin, where is Judge Breslin? Oh, you are. You see, if I can't see back there and read at the same time, so I have to keep. So anyway, I want to thank especially Judge Breslin, who actually appoints all of the committee members and who has been very supportive of the committee's mission and work. And of course, Judge Thomas Breslin is the administrative judge for the 3rd JD. A groundbreaking, good. We just started, Judge Grappio. A groundbreaking report recently released by the New York State Bar Association entitled, "If Not Now, When? Achieving Equality for Women in the Courtroom and in ADR." That report confirmed the obvious: women are grossly underrepresented as arbitrators and mediators, especially in complex, high-stakes cases. And the evidence is overwhelming. The International Institute for Conflict Resolution reports that of 550 neutrals worldwide, 15% are women. A study issued by the ABA Dispute Resolution Section found that in cases with over $1 million at stake, 82% of the neutrals and 89% of the arbitrators were men. Male neutrals handled 93% of intellectual property disputes, 91% of insurance disputes, 82% of corporate and commercial disputes, and 79% of class actions. And of course, those are the most lucrative cases. On the other hand, women feature prominently among low and unpaid mediators handling disputes in family and small claims courts. And I believe some of those wonderful women are with us today from Mediation Matters, which is the group locally that does that mediation. And I know that a majority of those volunteers in Mediation Matters are women. So, does anyone see a troubling inverse relationship between the amount of money in contention and the probability that the arbitrator or mediator will be a woman? Yes, I know. Those are the state, national, and international statistics, and unfortunately, I have to say that we are not only no better in the 3rd Judicial District, we're actually worse. One of the leading mediators in the state recently described the Capital Region Brotherhood of Mediators and Arbitrators as, quote, a white male wax museum, and told me that I was, quote, more likely to find Elvis mediating a high-stakes dispute in the Capital District than a woman or a minority. Now, that is a bit of an exaggeration. It's not quite that bad. I personally am aware of 2 women arbitrators in the Capital District. 2. And one woman is on the appellate division list out of 10 in the Capital District, in the 3rd Department, I should say. And despite Judge D'Agostino's considerable efforts, the Northern District Federal Mediation Panel is not as diverse as it could be. And I will say, though, that progress is being made thanks to Judge D'Agostino. NAM was kind enough to provide me with their upstate arbitration panel, which contains only 3 women out of 38 arbitrators upstate. But I want to quickly add, in fairness to NAM, that they are aware of this problem and have been sincerely trying to address it. And one of the steps they've taken to address it is to sponsor programs such as this. They're not sponsoring this program, but they have been very helpful in providing one of our presenters and in providing that lovely package of materials, which, by the way, they put together, but Judge Graffio was the one to suggest most of the articles contained in this package. Oh, and I should also thank NYSPA, the New York State Bar, which gave us permission to use all those materials. Stephanie is here from NAM, Stephanie Ball, and came all the way up with Judge Moskowitz from New York City in the midst of this 4th or 5th nor'easter that they're suffering down there, so they went above and beyond. In putting this program together, the Gender Fairness Committee looked into why women are so poorly represented in ADR, and I don't think any of us believe, especially in this day and age, that there's any overt or abject discrimination. In fact, I think it's simply a matter of inertia and lack of awareness. Mediators and arbitrators tend to be drawn from the same pool from which they've always been drawn, giving little or no thought to diversity. ADR companies tend to retain former appellate judges, and they're great, for sure. But in this area, that's almost always a male. And many women litigators who would make excellent mediators or arbitrators either don't know how to break in or simply believe that it's a closed shop. Today's program is designed to raise awareness about the problem, reveal how the selection process works, and provide some insight into how to break in and fit in. We have an all-star panel, but before I introduce our presenters, I'd like to introduce Alicia Willett, the 18th Dean and President of Albany Law School, and only the 2nd woman to hold that position. Dean?
Hi, everybody, and welcome. I'm pleased to be here. I'm just going to take a moment of your time to thank you and to say how proud we are at Albany Law School to be hosting this program. Ensuring gender equity, as well as equity based on race, ethnicity, religion, sexual orientation, gender expression, social class, and disabilities at the heart of what we do at Albany Law School. We are graduating a generation of lawyers and leaders who are going to be committed to ensuring equity across all of these categories. And so we're proud to play a small part in today's program. We have a stellar panel. You're going to hear from Judge Kretzer about all of their characteristics and all they do, but I want to make sure to welcome all of you and thank you for being here. Many of you are very special people to the law school, and we're glad to have you here. And I want to thank Judge Kretzer, who teaches at the law school, and we've adopted her as one of our own. Congratulations on putting this together. I know it's been a lot of work and a project, a labor of love for you.
It is a labor of love for me to be both an adjunct and to put on this program. Thank you.
And as you know, teaching our students, as well as Judge D'Agostino knows, teaching our students, we're teaching an incredible and impressive group of students. More than half of them are women. And many of them are committed to going into alternative dispute resolution. We have at the law school a mediation apprenticeship clinic where our students consult directly with clients on landlord-tenant disputes, contract disputes, and other civil issues. They receive 30 hours of training in mediation theory. They work with Mediation Matters, and skills as prerequisites to enrolling in the clinic. I'm pleased to say that in the past year, we've had a 6-to-1 ratio of women to men in the course, so perhaps this early training will pay off in some of the issues that we're going to address today. And these are serious issues, as Judge Kretzer laid out. We're going to learn a lot today about why the disparities continue to exist and what we can do about them. I hope you all enjoy today's program, and thank you for being here.
Thank you so much, Steve. And thank you very much for hosting today's program. Okay, before I introduce our panelists, I would be remiss if I neglected to thank our many friends and co-sponsors who make these programs possible. Believe me, it's not easy to put on free CLE programs. It really does take a village. And the Albany County Bar Executive Director Marquita Rhodes is outside doing so much work. They take all our registrations and they give you all those important CLE certificates. So we owe them a debt of gratitude. And by the way, those of you who registered in advance will be able to pick up your CLE certificates at the end of this program. Those who didn't register will get them mailed. And the Albany County Bar is great about doing that in a timely manner. And of course, Albany Law School for hosting today's program, the Capital District Black and Hispanic Bar, the Capital District Women's Bar. I saw a number of people here from the Capital District Women's Bar, the New York State Bar, and we have 5 sections: the judicial, commercial, and federal litigation, the women in the law, the alternative dispute resolution, and the senior lawyer sections, all co-sponsored today's program. The Northern District of New York Federal Court Bar Association, the Legal Project, and finally, last but not least, the National Association of Women Judges, New York chapter. Now, a quick note about our format before I introduce the panel. We'll be taking questions from the audience following each segment, but because the program is being webcast, so remote participants won't be able to hear your questions, we've decided to pass out index cards to all of you. So just as you're thinking of your questions, jot them down, and one of our wonderful volunteers will come by and pick up D. One of our wonderful volunteers will pick up the index cards and give them to me so that I can read them at the end of each segment. Now, to our presenters, and I will introduce them alphabetically. You do have their impressive bios, so I'm just going to say a few words about each of them, but I do encourage you to read those bios. They are impressive. Judge Graffio, former judge of the New York Court of Appeals and current partner at Harris Beach, who leads the alternate dispute resolution practice group. Judge Graffio was the first woman from the Capital Region appointed to the state's highest court, and we're very proud of her. Judge Carla Moskowitz, Associate Justice, retired, of the Appellate Division First Department, and Special Master for the Appellate Division and arbitrator for NAM, the National Arbitration and Mediation Association, one of the nation's leading arbitration companies. Judge May D'Agostino, Federal District Court judge, who is only the second woman in history, in the entire history of the Northern District, to be appointed to that position, and the only woman in the Capital District to ever sit on the federal bench. Now, Jim Hacker was unable to join us because he's stuck in a jury trial, but he sent his partner at Jones Hacker Murphy, Mark Saunders, who is renowned in his own right for starting the area's most successful mediation arbitration practice. So I think this is the perfect panel because in addition to their stellar credentials, you have perspectives from someone who is an arbitrator at one of the most respected national arbitration panels. We have the perspective of a federal judge, and since mediation and arbitration is a valuable component of federal practice, that's an important perspective. We have Judge Graffio from one of the largest firms, 10, upstate certainly, 10 offices, I believe, who heads their alternative arbitration practice. And, of course, Mark, who, as I said, started his own very successful mediation and arbitration practice here in the Capital District. So it's really the best of all perspectives here. I'm going to ask Judge Moskowitz to start us off.
I think we
with
were going
the
alphabetically.
No, that was the introductions. No. You get to start us off because you're going to talk about the report.
That's
that
right.
was actually the impetus for today's program. And I don't know, you can either take the podium or
Do you want me
remain
over
seated,
there?
whatever you prefer.
Okay, I'd rather stay seated.
Thank
Well, now, you've covered almost everything we could cover in this session, but we'll elaborate. You have your written materials, and if you don't know about the report or if you haven't read it, this is the time to read it. I don't mean while we're talking, but you should read it because it's about New York, and it's about what really goes on in the courtroom and who's really, really arguing the cases. And this report actually started on my court. Sorry, I know a lot started here, but it started on my court, the Appellate Division, First Department. The women, we had no women on our court. We had one, and then two, I was the second, and then all of a sudden, half of us were women, and we were ecstatic about it. But we thought, well, what should we do? We have an obligation to help women lawyers, and how do we do that? And we looked around, and we thought about what we saw in the courtroom every day, which is that women were not arguing the big cases, the big personal injury cases, the commercial cases, because we got a lot of commercial cases in New York County, from the commercial division. The women may have been in the courtroom, but they were handing up the material or writing the notes for the partner arguing. And we said, what is going on here? And what we did, we said, well, everything we talk about is anecdotal, and that doesn't mean anything. So one of our law clerks, a couple of our law clerks sat down and took a month and look, and you can tell who's arguing a case, and did the statistics on who was arguing what case, what case it was, what appeal it was, and who was arguing. And there we had the evidence that the number of women in commercial cases was almost negligible. There were women arguing for this in public cases and in cases involving children, but there was almost the statistics were almost none in the cases in which, of course, there was a lot of money. And we had this, and then at the same time, the commercial, we were working through the city bar, New York City Bar on this, and then the state commercial and federal litigation section, the head of that section, I give him credit, a man, Mark Berman, said, we should take those statistics and look at them throughout the state. So there was a women's committee formed, and the heads of that committee were former women chairs of the section. But I was on that committee, a lot of us were on that committee, and we devised a questionnaire for judges, for attorneys, in court, in arbitration, in mediation, as much as we could, in federal court, state court. Take a look at a period of time and count who's in there arguing these cases. And the statistics came back the same way and were put into a report. And they sat down, we looked at there was a report generated, we edited the report very lightly, and then it got published as this for the commercial and federal litigation section, and then it was adopted by the State Bar Board of, Delegates, Board of Delegates, as a report of the New York State Bar Association. And then in February, at the meeting, I think you were there, the American Bar Association adopted it as a report. And so it's a really important document because it's looking at the courts here in New York and, as much as possible, mediation and arbitration on numbers, actual numbers. Now, there is one in here. There's an American Arbitration Association, also statistical look at the courts. But that is, that's a few years older. But the statistics, of course, are the same. And this is our state where we live. So what the committee is doing now is going to sit down at the next meeting, which I think is up in New York's, upstate New York, and sit down and say, well, now what do we do? The first things that have been done is a lot of the women have gone and spoken at law firms to talk about the pipeline, to talk about giving the people who actually work on the briefs an opportunity to go to court and actually argue. They've gone to judges, met with judges, and the judges, some of them spontaneously, have changed their rules about arguing of motions, saying that they're encouraging the motion to be broken down and argued by different people, so that the person who actually did the work has an opportunity to go to court and argue part of it. You have to realize that in these big cases, I guess you all know, in the big cases, it used to be, when I was in the commercial division, it used to be the attorney that was arguing the case would come, and sitting next, on one side would be the lawyer who actually did the work, and on the other side would be the lawyer carrying the books. The first, second year associate was carrying the books, the fourth, fifth, whatever, fifth year associate actually did the work. And there would be 3 lawyers there. Well, the clients don't want that anymore, and they don't want to pay for 3 lawyers. They want to pay for 1 lawyer. So what's happened is that whole experience of at least being in the courtroom has disappeared. So it's all the more important to convince judges to break down that motion, to break down what has to be argued so that more people could do that argument, because the firms are not going to pay. They're not going to take that money out of their pocket for the second-year associate or first-year associate to come to court and carry the books. They're going to only put 1 person in there because the client's going to say, what are you doing with all those people? You don't need it. So the whole culture in these commercial cases has changed. But still, there's ways of getting more people, more women, and actually minorities too, to get into that courtroom. And the same thing holds for arbitrations and mediations, but it's harder because it's not open like the courts are. So it's harder to really find out what's going on. Now here in Albany, I understand you really don't have NAM, you don't have JAMS, you don't have any of the other services with offices here.
No office, but we do have a few NAM arbitrators locally.
Right, but you don't have like what we can go online in New York, and you could see the faces and the experience of all the arbitrators at NAM. And I guess if you want, the lawyers will go get someone from New York, but I don't think that's going to happen. I think Mark, you were saying you started. No, you didn't. Did you start something where there's a few of you together, working together? That would be great if you could increase the people on your panel that are working with you, so that there's more of an opportunity, there's more of a chance that a minority or a woman would be picked. So I think that's one thing that has to happen. I think that you have to educate the corporate people who are picking the arbitrators, who are picking the people who are going to argue. You have to, the whole law firm culture has to change. And actually, as I've been thinking about this, I came up with something, and I don't know how it could work. Before I became a judge, I was in New York City, and it was very difficult for women because they had no idea how to become a judge. So I got together with a few women who felt the same way, and we created a program called How to Become a Judge. Now, you may have had that program here, I'm sure you have, but we held it when, yes, that's right. You have it here, but we started it because women were not, may have come out of a committee to get elected to be a judge, but then they never got the political backing. So we started this program so that, and it was for women, but men could come. And it was for people who wanted to know how to become a judge, either elected, appointed, or whatever the different offices were. And I'd like to think it was very successful. And I don't think it's a result of that, because there were then more women, but there were more women that got on the bench. And so we started that, and as I'm sitting here preparing for this program, I got a call from a Hispanic woman lawyer that I know about the Puerto Rican Bar Association down in the city, and she's been in practice a long time, and we started talking about what I'm doing here, and it occurred to me she would be a great mediator. And she said, I don't know the first thing about becoming a mediator. So now I'm thinking, maybe we need to have here and in New York and in other places a program on how to become a mediator arbitrator.
Well, that's one of the things I hope to address, at least in the short version.
Okay,
today.
but I think you need a little longer version.
Yeah.
And so I thought, that's a great thing. We could do that too.
Yeah.
New. That's my take on it. But I do think that when you have time, you should sit down and read the report and say, what is going on here, and let's fix it, at least in this region.
Thank you. Now, Judge Moskowitz has been, I don't want to date you, but she has been, when she started talking about becoming a judge, she has been around a long time. I thought there was a typo on her resume.
Right, you did.
She really is a pioneer and was there at the beginning. You know, I won't give the year, but
It's okay.
Okay. 1966 you were graduated, or?
I graduated from law school
Law
in
school.
1966.
Yeah.
Someone said that to me once. They said, isn't that a typo?
I thought that was a typo.
No.
Yeah.
Other people have said that, no.
Yeah. Anyway, so thank you for giving us that history of the report, because I knew a little bit about this report, having talked with one of the authors who stays at my house whenever she goes to the House of Delegates meetings, and presented this report to the House when it was adopted in November. But I didn't know all of that extra background about the First Department's involvement, so thank you. So now that we know a little bit about what's going on in terms of the statistics provided both by the report and some of the ones that we gathered in my committee, I'd like to take a look at why. Why are women on the outside looking in? And I don't know, I think I'm going to put our panelists on the spot a little asking you that, but, and Mark, I'm sorry to do this to you, you're the brave male representative on this panel, but you've been in the game a long time, you and Jim, and so maybe you're the best person to start by giving us your perspective.
Sure.
Why are the women on the outside on this?
Are you talking about Betty Lugo? She's amazing.
I think listening to Judge Kretzer's opening remarks, I guess I'm the white male from the Wax Museum who is on the panel. And I suppose I can also distinguish myself by being the only person on the panel who has never been a judge.
Mark, could you get closer to the mic? Thank you.
Sure. I'll try. Is that better? Yes. Sorry. So, by way of background, and maybe to follow up on what Judge Moskowitz said, I've practiced law for close to 40 years. I was a trial lawyer. I did mostly insurance defense work. And I was with a large firm by upstate standards when I decided to pack it in 2007 and go skiing for a couple of years. And then I got restless and called Jim Hacker, who I knew because Albany is a small town where people know each other, and particularly people who tried cases know each other because they were in the courtroom a lot. And he gave me a seat, and what I was looking to do was to start a mediation company. But I had to market myself. So I guess what I can bring to the table, and I had 2 days to think about this because I'm a
Yes,
substitute.
thank you again for filling in at the last minute. Yeah.
But I started at absolute zero. I had been an advocate at mediations. Frankly, and I was talking to Judge Moskowitz in the hallway, one of the best mediators I ever encountered was a woman named Ronnie Galina,
Ronnie
downstate, 20 years ago. And I don't ever remember anybody saying, oh, we can't use her, she's a female. And in the 2 days I've had to prepare this, I had mediation Monday, Tuesday, and today, and I asked the lawyers, have any trouble with that? Mediating with a woman as opposed to a male? And I got these quizzical looks. Nobody cared. So the question is, why not? And why not now? I think it's an appropriate topic. So let me give you a little idea, if you'll bear with me, about how I got started. I wasn't a judge. Quietly was going about my business, trying cases throughout the state and staying in every Holiday Inn, and I can give you a good outlook on all the Holiday Inns and the county courts, county courthouses in the upstate. But I didn't really know how to go about changing course and starting a new business after 35, 40 years trying cases. So the first thing that came to mind was, what do I know? And all I knew how to do was what I'd been doing for all those years. So my first suggestion is figure out what should be on your calling card. If you've been doing labor and employment, don't hold yourself out as a matrimonial lawyer because people won't believe you, particularly in a small town where everybody knows everybody. The second thing was how to market the mediation business, mediation arbitration business. And so I talked to Jim Hacker about it, and we decided to bring in some other people, and turns out that Jeff Anderson, who a lot of people in this room I'm sure know, was operating under the same, actually on parallel tracks, and was thinking of starting a mediation company with Paul Gireller, who is a lawyer who does defense work in town. So my first order of business was to start to call lawyers that I knew and seeing if they'd be interested. And I happened upon Jeff, who I also had met in the courtroom, on the other side, always on the other side.
Jeff Anderson.
Jeff Anderson
is an adjunct at this law school. Some of you may know him.
So the four of us decided we had to market the mediation business, so we came up with a name. We called it Litigation Resolution Services because it sounded good, along the lines of Kodak, which has no meaning, but it sounded good at the time, so that's why Kodak is Kodak, and that's why we were Litigation Resolution Services. And we set up an LLP and started going about marketing the business. First thing I did was to get a list from the New York Bar Association, which is available, of every lawyer who belonged to the New York Bar Association and their address and their contact information. And I went through hundreds and hundreds of names, picking out the people who were doing the kind of work that we were trying to market, which was personal injury cases, contract cases, commercial law. I did a lot of insurance cases, so I was looking for that. And then we made a cheap flyer and sent mailers out, and then started going to Bar Association events and promoting the business. And that's when patience set in. It took me, I would say, 2.5 years before I got any traction. In the meantime, a case would dribble in here and there. I managed to get on the Northern District panel for arbitrations, early neutral evaluation, and mediations. Judge D'Agostino, is that still open?
What was that?
Is that still open, the Northern District panel?
Oh, absolutely. I'll be talking about that.
Okay, good. Then I'll gloss over that and leave that to you, because you certainly know more than I do about it. But I made an application to be on that panel, and I was accepted. And at that time, it was pro bono. But I knew if I did enough mediations with the federal court, even if I wasn't getting paid, if you have 2 lawyers or 3 lawyers in your mediation and they're pleased with what happened, they'll all have other cases, so that your 2 become 4 and 4 become 8 and so forth. And little by little, it expanded until now I'm about as busy as I want to be in my old age. So there was no magic to it. It was patience, perseverance, and self-promotion. As far as certification, maybe I should admit this, but the only course I ever took was the compulsory course that the Northern District made all of us take, so I took it. But I had been to a lot of mediations as an advocate, and I had an idea of how they were done. I knew what I thought worked and what didn't work. I'm convinced that you have to know the substantive law that you're dealing with, but in doing the mediations, patience and perseverance is as important as intellect or understanding the substantive law. It's how you handle the mediations. I am more than happy to talk to anybody who's interested. The pie is growing. Fewer cases are being litigated for a variety of reasons, which is a subject of another lecture, another time. But I truly believe that there is no reason why women can't do it. Just figure out what you do well and buckle up and market yourself. In response to Judge Moskowitz's comment that we should expand our company is a marketing company. It wasn't like NAMS or JAMS. People don't make appointments. Like if you want to use JAMS or NAMS, you call JAMS or NAMS. With us, you call me, or you call Jim Hacker, or you call Jeff Anderson and set up an appointment, or you call our offices, and that's how we do it. The litigation resolution services is nominal at most. The billing is separate, the scheduling is separate. We did it in order to get some traction in the beginning and to get the members of the bar who did the kind of work that we were trying to be involved in, aware of who we are and what we did.
But have you ever considered expanding your practice a little bit, just to cover some of the areas that you personally are uncomfortable covering, like labor, employment law? What am I missing? There are other arbitration mediation subject areas that I believe there's a need for locally, and a firm like yours would probably be perfect to consider expanding, if I may be so bold. But
I'm of counsel, so the hiring is not my department no more.
Yes, Jim Hacker would have been perfect for that question.
Yeah. I used to manage a firm, but those days are gone, and I do not miss them. What I will say is, personally, I try to stay in my own, to borrow a Warren Buffett term, circle of competence. I've been doing, by and large, the same thing for a long time. I feel comfortable with it. I go in, so if somebody calls me and wants to do, say, a matrimonial mediation, I first of all tell them I am utterly incompetent in matrimonial law. When I took matrimonial law and family law in, I think, 1971, the rules were different. I have not a clue about how it's practiced now, and I will find somebody who is competent to handle that for them. So I try to stay in my own circle of competence, which is you know, personal injury work, insurance work, contracts, and I've managed to spread a little bit, but not too much.
Well, thank you. Now, you mentioned, so it gives me a good segue, you mentioned the federal panel. So we have an expert on that and many other things. And I think Judge D'Agostino brings an interesting perspective because prior to going on the bench, she served for decades as one of the top litigators in the Capital District. Judge D'Agostino.
Thank you. I am going to talk specifically about the Northern District Mediation Panel in just a moment, but I just want to say a few things before I get into the specifics of our program. I'm a very practical person, so I'm just going to give you a few practical pointers in terms of getting on our panel and being able to be a mediator in general. I think that everything that a lawyer does from the minute they start practicing up until the time that they achieve their goals is being watched by everybody. What do I mean by that? I mean, if you're setting the goal that you want to be a mediator or you want to be the world's greatest litigator, whatever it is you want to be, you're being watched. And what I mean by that more specifically is that when I was practicing, I did hundreds, if not thousands, of depositions. I read millions of pages of young lawyers' writings. You know, a senior partner might have signed it, but I kind of knew who wrote it. And if I'm in a position of authority and I'm looking for somebody to be a mediator or somebody to join my own law firm, everything that I've seen about you in all of the depositions that I've been to and everything that I've written is going to play a role in what I do. So my message is, do everything that you're doing in your practice better than everybody else, because you will be noticed. When a young lawyer went to a deposition with me and said, "Hey, May, do you mind taking the lead?" That was bad, because I'd rather see a young lawyer take the lead, do the best that he or she could do, and then offer some advice. When I read affidavits in opposition from young lawyers that were really poorly done, I would think, I don't really think I would want that person at my firm. But on the other hand, when I saw really good, hardworking, talented young lawyers, I would try to steal them. So my message is, whatever your goal is, and I'm sure that all of you are interested in mediation, get noticed. And you get noticed by really doing your job well. There's just no other way to put it. Because older lawyers and people in positions of authority who are looking to fill slots will think of you. They absolutely will. To be a mediator in the Northern District, you have to simply apply. And I checked with our court clerk, Larry Behrman, who told me that we will be opening up the panel this August. And I've asked him to send the application to the Women's Bar Association so that there will be an extra notice to anyone who wants to apply for the panel. I realize that people are not getting to try civil cases now, and I realize that Some people are not even getting to do a lot of depositions. But the nice thing about the application for the Northern District is that, it begins by asking you if you've ever been disciplined, and if you have, that's not a good thing, I assure you. And a corollary of that is, not so much upstate, but there are parts in the state where judges will sanction you, they'll just sanction you for things like being late or, having poor papers or something like that. Don't get sanctioned by a judge, because that really messes up a lot of things that you will be applying for in the future. But in our application, it asks what kind of practice you have, and it runs the gamut from admiralty, antitrust, banking, commercial. I'm not going to name all of them. Corporate, employment, entertainment, environmental, ERISA, estate planning, health, trademark, intellectual property, sports, RICO, real property, products liability. And we just ask you to put the percentage of your work in those areas. But there's nothing on here about how many cases you tried, which is probably good for a lot of young women and young men, because so many cases are being settled today. So if you've developed expertise in any one of these areas, or you feel that you really know any one of these areas, by all means check them and give a reasonable percentage as to how often you've done that, okay? Now here's another interesting thing. Our application asks if you would be willing to serve as a mediator in the following areas: Albany, Syracuse, Binghamton, Utica, Plattsburgh. Well, if you're really, really interested in serving as a mediator, you might want to check Utica and Plattsburgh, right? I have nothing against Utica or Plattsburgh or Binghamton, but don't just check Albany. Be willing to go where there is a need. Because we have a little courthouse in Plattsburgh, for example, and of course we have courthouses in Utica and Binghamton as well as Albany and Syracuse. Our form says that training is not required, but I will tell you that every once in a while our chief judge will order training, and everybody on the panel is expected to go. That's another thing. If you're considering it, why not sign up for some training now? And you can hold out to the committee or the company that you're applying to that you've had the training. We ask if you have any experience being a mediator in the past. Some people don't, but if you do, that is a definite positive. Another interesting question is, are you willing to serve as a mediator without compensation? Now that's an interesting topic, because we know often that women are paid less than men, and we don't want to be in a situation like that. But to break in, if you check yes, you would be willing to do some without compensation, you do a bang-up job, the lawyers start talking about how good you were, that could do a lot for you, so consider that. And then you're asked some ministerial questions about, are you familiar with ADR and its procedures, and do you perform pro bono service? So if you're from the Capital District, you can apply for a position as a mediator, because we have mandatory mediation beginning in August. We will flag this to the local women's bar associations, and if you don't apply, you can't be considered, right? People come to me all the time. Do you think I should try to be a judge? Do you want to be a judge? I say yes. Well, then try to be a judge. If you want to be a mediator, apply. Try to be a mediator. We have a mediation committee in the Northern District. They review the applications, and then they bring them to the full board of judges, and then the full board of judges votes on it. And the last thing that I want to say is reputation, and not just for good work. I mean, nobody wants to mediate a case in front of someone if we don't truly believe that they have impeccable credentials, because we tell secrets to mediators. And we want those mediators to keep our secrets. So your character for truthfulness in the legal community, your character for integrity means a lot. Like, there are people that I litigated over a 30-year period who, just jerked my chain needlessly so many times that they wouldn't necessarily be the first person, if I were a private practitioner, that I would want to mediate. So your whole character for no nonsense, being a person of your word, because as the mediators in this room know, we tell secrets to mediators and we ask them to keep our secrets, and that's very important. Finally, if you're a woman practitioner, why not pick a woman from the list? We have some fabulous, albeit our numbers aren't great, but we have some fabulous women litigators, women mediators on the Northern District panel. Why not tell your clients, I know that you might want so-and-so, but there is a woman on this panel that I think is dynamite. Let's go with her. I mean, let's help ourselves. Educate our clients that women bring a whole different set of skills to the table. In the Capital District, we have some fabulous commercial and personal injury litigators. So what I'm saying is, if you're looking at a list and it's men and women, why not pick the woman? And why not educate your clients about, picking a woman mediator or arbitrator? And I have begun as a judge issuing orders, asking individuals who are making oral argument in front of me to give a young lawyer a chance. And I am telling them that I will give them a little more time if they will bring a young lawyer with them and let the young lawyer argue. So I also have begun doing that.
Thank you, and that's very good to hear. So what Judge D'Agostino has told all of you is that basically it's a two-step process. She's told you how to go about getting on their list, and then, of course, the next step is getting somebody to pick you, getting the clients to pick you, and encouraging clients to pick diverse mediators. So thank you for that. I just have a couple of practical questions. The cost of the training that's required often to get on the list?
Judge Treese, we didn't charge, did we? It was free.
Free? And thank you, Judge Treese, by the way, for being here. Judge Treese is an arbitrator locally and was, as everybody probably knows, federal magistrate locally. Now, how much, since I'm asking practical questions, how much are these mediators paid?
How much are they paid?
Yes.
I don't know today's going rates. Mark?
Oh,
you
no,
mean-
on your list, isn't there a federal?
Yeah, what are they paid, Randy? $325 for 2 hours.
Would you like to come up here? Thank you. So that's a lot of good information. Now, we have heard the small firm perspective. I would now like to turn it over to Judge Graffio to give us the benefit of her wisdom about how to break into the large firm arbitration process. Judge Graffio.
Thank you. Good afternoon, and thank you so much for your interest in ADR. In the past 10 years, alternative dispute resolution has really come into its own. We have a separate section of the New York State Bar Association that is now an ADR section. So if anyone is interested in becoming a mediator or an arbitrator and you are a member of the State Bar, I'd strongly suggest that you join that section, because they run training programs every couple of months, and they have meetings, and it's a chance to really gain knowledge from more experienced people in this field. And it's also a way to get your name out there and to kind of market yourself. I'm going to ask, do we have any law students here? Okay, there's a few hands went up. Let me just mention that there's a very considerable difference between arbitration and mediation. And, you know, if you haven't taken any classes in this, you're not going to understand the difference. But arbitration is a much more formalized process. In the Capital District here, it essentially, I would say, breaks down into commercial arbitration and maybe vendor-vendee arbitration and labor employment arbitration. Arbitration essentially comes from a contract. Usually the parties, as part of one of the terms of their contract, provide for arbitration in the event of a dispute. Sometimes it has to do with only certain types of issues. Very frequently, the scope of authority of the arbitrator may be addressed in the contract. So frequently, they tend to occur in what I'm going to call a business environment as opposed to individuals. But I have done arbitration that has been on a regular general litigation track, and the parties have decided they don't want to take the time that they're going to have to go through to wait for their trial. In theory, arbitration is supposed to be far more expeditious. It is intended to have less discovery, and there is some laxity in the rules of evidence. So in order to try to, in certain, especially commercial situations, just getting a decision is more important than the process, so parties may decide to go the arbitration route. Arbitrators are very carefully vetted, and the more sophisticated and the more the commercial value, the dollar amount on the case, the more difficult the vetting is. For former judges like myself, the parties are looking at everything you ever wrote in a case, because if you put out a decision that went against the issue in their case, that's it, you can forget about it. They're going to look, I'm asked about my training, I have to submit, CVs, I have to, especially if you're involved with major corporations, there's a lot of requirements and materials that they're going to want from you. There's formalized forms. There are national groups that promote arbitration. I am one of the AAA arbitrators, American Arbitration Association. I do indicate to you that if you are interested in arbitration, especially here in the Capital District, you probably want to enroll or be accepted by one of these groups. Some of them are by invitation only. You have to be nominated and recommended. The training programs are not inexpensive for arbitration. AAA training programs start over, I would say they're over $2,000, so you've got to be serious about wanting to do this. On the other hand, mediation, as Judge D'Agostino mentioned, you can begin to get into the ADR field at a much more affordable level. The State Bar, we're hoping that through this program and through the increased efforts of the people involved in this panel, that we want to get more diversity in terms of the mediation services available in the Capital District, that we can get perhaps some of these organizations to do some of these training programs more locally. Most of the State Bar and other organization ADR trainings that I've gone to have occurred in New York City. The State Bar program for general mediation is 3 days. They do have a list, the State Bar does have a list on the website of certified mediators that have successfully completed their training. So you have to spend 3 days in the city. But the difference with mediation, you are a facilitator in mediation. In arbitration, you are actually the decision maker. You're going to write a decision. It's almost like a quasi-judicial proceeding. The arbitrator has to do the research. The arbitrator has to issue a decision. In most instances, it's going to be a written decision. There are very particular codes of ethics for arbitrators. Bias is a major issue in arbitration. And of course, some
We'll get to the
arbitration.
ethics. I'm going to do that in a separate segment.
Right, that's
Yeah.
a separate. In mediation, you may not be asked as specifically what your training is, but in order to market yourself, I think it's very helpful to go to some of these training programs. It's also, it's going to assist you in understanding what the parameters are of mediation. As Judge D'Agostino said, the number one criteria is reputation. Number two is experience. And number three is, I say, personality, getting people to trust you. A successful mediator has to very quickly gain the trust of all parties involved in the mediation. If they don't trust you, they are not going to reveal what they really want. They're not going to be open to discussion, and they are not going to be conducive to listening to your suggestions on what may be the weaknesses of their case and what they should consider. I think one of the great aspects of mediation, and why I enjoy doing it, is that it provides for a lot of creativity. You can come up with solutions to disputes in mediation that are unavailable in the usual litigation process. Judges only have so much authority about what to do. In mediation, you can really come up with some different proposals when you get to know what the relationship is between the parties, what their real primary concern is. Oftentimes in a commercial context, you can negotiate so that the relationship can continue, but on different terms. In personal mediations, you can sometimes provide for different kinds of benefits or resolutions that are not available as a remedy at law. So I think that there's a lot that a mediator can do. It's a time-consuming process. I just finished one last week that we spent 7 hours before we really got down to brass tacks. But, you know, sometimes you have to wear down those insurance adjusters who are there for a while before you're able to make some real considerable progress. So I think it's very rewarding to be a mediator. It sometimes happens, I think, too soon in the process. Mediation is most successful where both sides feel there's something to be gained by settling the case. If a lawyer comes in with the client and they sit there and they immediately tell me within the first 10 minutes, we are right, we are going to take this to trial, they're a give me all, I'm not interested in this process, mediation is not going to work. Mediation, I feel, works best when both parties voluntarily have elected to mediate because they both have something to lose and they are hoping they have something to gain. And I think that that's a critical difference. Arbitration is, because it's a contractual obligation, it's often done voluntarily or involuntarily. The parties have agreed to an arbitration. Sometimes they wish they hadn't, but they have. So I think there are considerable differences, and there are different approaches that you take. In most training sessions, they are going to tell you that mediators are not there to place a value on the case. But the reason I mentioned experience as a second important criteria is because you do have to have in your mind as a mediator some idea of what the case is worth so that you can help to direct the parties to that, what I call the sweet spot, where they may not be ecstatic when they leave the room, but they're going to feel that they had a fair opportunity and that they've both gained something from the resolution and the settlement. So in most cases, the mediator is there to facilitate discussion between the parties. I always begin my mediations by explaining to the parties that it's really their process. The parties get to participate and to express their thoughts and their concerns far more than they are able to in a litigation context, because there's no judge that can spend 3-4 hours listening to any litigant at a settlement conference. That's just not feasible. But you are able to spend a day or 2 days in a mediation so that people really feel they've been a participant in the process. You need to be a people person to be a successful mediator, and you need to have the reputation with the attorneys in your community that they feel that you are ethical, that you're trustworthy, you're going to keep the confidences, as the judge said, because I have all my pre-mediation reports come to me confidentially. I don't have parties exchange them unless they really ask me for that. And the reason is because I really want to know what all the information is, the good, the bad, and the ugly. And then I say to them, what do you not want me to share with the other side? But being the repository of that information, I sometimes can trigger a discussion about something that may not have otherwise have been revealed. Sometimes there are intangible things that people want in mediation that wouldn't be available in litigation. You know, certain kinds of apologies, certain kinds of other types of change in policies. Oftentimes, perhaps in a labor mediation, the parties will say, well, you know, in the future, I don't want anybody to have to go through what I went through. You can have that also, I think, oftentimes in a commercial context, but very much so in an employer-employee mediation. You have a lot of mediation in partnership disputes. And partnership disputes can be akin to matrimonial, if not worse in some instances. The vindictiveness and the anger is at the same level, if not higher, than parties that have been separated and are heading toward a divorce. So it takes a lot of allowing people to air their grievances in mediation. So there's a lot of human psychology that you discuss at some of the formal training programs, how to handle very angry, how to handle recalcitrant parties. Sometimes lawyers are worse than the parties, but yeah, it's a very interesting dynamic process, and I think that if you develop that area of practice, it can be very rewarding, and attorneys will frequently thank you, as I'm sure, you know, Mark has gotten, and I'm sure that Judge Moskowitz has gotten. You know, it's nice to hear from parties afterwards, and sometimes a mediation will not resolve the matter, but 2 or 3 weeks later, you'll get a phone call from one of the lawyers, and they'll tell me, we were able to settle the case. You know, we kept talking. I always tell parties, if you want me again, just call me, and we can further discuss this by phone. But every once in a while, it's nice to know that you at least made some progress in the formal mediation proceedings, and then the parties were able to continue their discussions and resolve the case. And, you know, anytime people can resolve their disputes peacefully and without being in the courtroom, which usually only further breaks the relationship, especially if it's something that has to be an ongoing relationship. I think that it's a very valuable tool for us to have in the legal profession. A lot of lawyers were initially resistant to mediation because, you know, go to law school, we're raised as litigators, it's in our blood, it's our nature to say this is how you get your client their justice. It has taken a bit of education for attorneys to realize that your clients can be just as grateful to you for a good settlement that they've participated in as they would be with a jury verdict. So I've spoken for quite a while.
No, but it was all very helpful. I found it very helpful. The arbitration program, or what, I don't know what you call it, the department at your firm at Harris Beach, is this full-time arbitrator mediators, or are they attorneys who do that as part of their process?
I think, I'm going to talk regionally here, you know, especially Capital District. I think it's very difficult, unless you have the reputation of Mark or Jim, to have a full-time ADR practice. It's a practice group in my firm. I probably spend less than a quarter of my time on ADR, but I consider it very important because I think the results of it are, I think it helps give the bar a good reputation for people to recognize that, yes, lawyers can also go through this process and help you settle your dispute. You don't have to spend 3-4 years in litigation. I could do more of it, but quite honestly, there are some more profitable areas that I practice. So, the law is a business, as we all know. It's a matter of balancing. And there are some cases that require certain expertise, so I don't do securities arbitration. You're going to find that those people are highly vetted that do federal securities arbitration, that type of thing. So there are some areas. It's growing in my firm. There are certain areas of the state where I think mediation is far more common. Lawyers are more accustomed to dealing with it. We have, as Mark said, a bar where so many of the lawyers involved in litigation know each other, that there's a lot of what I'm going to call private settlement discussions that go on in cases that are resolved. I think in terms of the diversity question that you have, that obviously, which is why we're here today, it all goes back to the fact that there's less opportunity for young lawyers, women, people of color to try cases. And it's in the courtroom that you get some of the experience that helps you, I think, to be a more effective mediator, because you begin to understand how to pose questions, what drives people, what the process is. And also, in mediation, you're talking to the lawyers about the strengths and weaknesses of their case. So if you've tried similar cases, you have some pretty good idea of what they're going to confront when they actually have to present their evidence. So I think it all comes back to more opportunities have to be presented so that people can develop the background that will help to make them successful.
Thank you. I could think of many follow-up questions, but I want to leave some of the questions for all of you to ask. So I'm going to move on to Judge Moskowitz. Would you be kind enough to let us know, how does somebody get on the NAM list? And we all know that NAM, the National
Arbitration and Mediation.
Association, has some distinguished panel members.
Yes.
How do you get on that panel?
Well, there is actually an application. It's online, and you could fill out the application, and you should call NAM. And the head of NAM is Roy Israel, and he will look at your application and decide whether it's a good fit or not. But I think before you do that, you should actually start taking some courses. I'm not sure what's given particularly here in the region, but I do know the State Bar, the New York State Bar Association gives a 3-day training in advanced commercial arbitration and mediation. In fact, there's one going on right now, and every year it gives various training courses. Do you have any in the?
Advanced commercial mediation and arbitration, I don't know that is offered up here. And one of the reasons is we have one commercial judge, Richard Platkin, and he often assists in settling those cases himself.
Well, what I'm saying is it's the New York State Bar Association that gives these courses. And some of them are you can get through the web. Some of these courses are only on the web.
And
So you have to look into
doesn't
that.
NAM offer its own courses?
Yes. NAM offers courses too. But I don't think you're going to get the kind of complete course you really should go through, because there's so many issues that you really need to get familiar with. I mean, there's the issues of conflict of interest, and they're touched on in one of the writings here, the issues of not just conflict of interest, but confidentiality, and because it's really different than litigation. And so you need to really have a lot of training, not just lectures, practice. I know this is the New York City Bar Association, gives a course in which you're actually going to go into a session with where you are either the lawyer for one side or you are the client or you are the mediator. And you have a 2-hour session in which I took it, so I know about it. I had a little piece of paper, and I knew what I wanted to settle the case, but I didn't know what the other side wanted, and the mediator didn't know what either of us wanted. And the client had another little piece of paper about what he really wanted, not just what he told his lawyer he wanted. And the other side, the same thing. And we all play acted different scenarios. Some were simple cases, some were complex cases, but it was very good training. Now, if you don't have that available here, make up a course. Or and you can invite the trainers that do it down there at the city bar to come here, because that was the best training I ever had.
I think Judge Graffio has some experience with that.
The State Bar course, I would strongly recommend the
Yes.
3-day course that you take in person, because that also has all the role-playing that Judge Moskowitz talked about. You don't know, they assign you, sometimes you're on one side or the other, or you're the mediator. They have experienced mediators who then critique you.
Yes.
They will tell you what your strengths were, what your weaknesses were. They will comment on the resolution, how you conducted yourself, what kind of language you used. You know, words take on a very precise meaning in mediation. You can phrase things in a way that breaks the chain of trust with the party that you're dealing with, or you can show some sympathy. So they spend a lot of time on what I mentioned before is human psychology, how to approach people. So it's a very good course. There's a lot of materials that you get along with it. And it is a 3-day commitment, but I think that it's a good training credential to have, so that as you're trying to publicize your availability to the local bar, you can indicate that you are on this list. And it does help you. You may get calls from out of the region as well.
And I'm sure that's a very expensive course, and one of the things that I'm hoping to do is make the State Bar and all of the groups and associations that provide CLE programs to factor in the cost when trying to diversify and recognize that not everybody can pay thousands of dollars to learn how to become a mediator or arbitrator, and offer scholarships in the appropriate cases. So we'll hope that that's part of the...
The other thing that you should do is really offer to be a mediator without getting paid. And there's so much need for mediators in family court. I don't know if you do that up here.
Oh, absolutely. And we do have some people here from Mediation Matters. Again, that's the pro bono. They will allow you, certainly, happily, probably, to participate in their program as a way of getting started. However, I, personally believe that women should not be the only ones doing the voluntary mediation. It's time for women to get paid. And so you can start by volunteering to get your feet wet, but after that, you need to be paid for what you do. And we women, often we don't recognize that. We don't market ourselves, and we don't demand what we deserve. So
We undervalue.
we undervalue ourselves, don't we? Okay, all right. Now, I think we should open this up to questions from all of you, and I hope that I might have some.
You do.
There you are. Thank you. Got it. Thank you for doing that. And that, by the way, was Judge Andra Ackerman, a member of our committee. So, this is for Judge Moskowitz. There are very few retired appellate female judges around here. Hello. One, I think, but no, two. But is appellate experience necessary to get mediation work? Basically, asking, he or she is asking from NAM, I'm sure.
I don't see that it is. The other thing that's interesting is that some people that are choosing mediators want to retain a former judge, whether that judge is an appellate judge or trial judge, but have the credentials of being a judge, which makes it harder for anybody who wants to go into being a mediator to get picked if you don't have judicial experience at all. So I don't know how you get over that except by becoming a judge, which is a different issue.
Well, we've done all those panels, but I would hope that all of the providers would open up their panels and not just go to the same old, you know, even though some of the same old are very good retired appellate judges. It's time to move beyond that.
Could I ask a question in terms of panels of three? There are a lot of contracts that require arbitration by panels of three. I don't know if you know what I'm talking about. Anybody, you know what I'm talking, everybody? Okay. Any questions about what I mean? That each side picks one, and then they pick, the two pick a third, or sometimes they're named in the contract. Sometimes it's AAA is the provider. Sometimes it's all different ways. To me, that is a good opportunity for a woman to be picked by the two side arbitrators.
Well, I'm
Whether
hoping
that
to
happens,
embarrass people to think that when they've got three panels, you know, a panel of three all-white males, that maybe they'll start to think, now that we've done this awareness raising, that it's time to throw in at least one woman or minority.
Well, one of the studies in the materials did a survey of that and found that most of the panels were three white men. And there were no panels of three women, and there were very few panels where there was a woman or were two women. So but to me, that's one way of getting women into arbitration and which is a different field, of course, than mediation, by having a woman on a panel of three, or at least one woman.
And you'll see in your materials, and I encourage you to read them, I don't want to get into it now because it's a whole segment in and of itself, why it matters, why diversity matters, both on the bench and for arbitrators and mediators. And there are studies out there, and they're cited in your materials, showing that the outcome of cases is actually different sometimes when there's a diverse panel, rather than an all, you know, generic, all white male, homogeneous white male.
Instead of different,
panel.
how about better?
Yes. So, thank you. Now, Judge Graffio, do you see the trend against litigation and toward mediation continuing, and why? Doesn't mediation frustrate the development of the law?
I think.
Touched on that, I think.
Yeah, I think clearly ADR is going to continue to grow in popularity because litigation is getting more and more expensive. Those of you who are involved in it know that expert fees, whether it's technical, engineering, architect fees, and especially physician fees, these things are getting quite expensive, especially for upstate New York. So I think that lawyers and litigants are looking for a more expeditious and more cost-effective way to reach a resolution in some of these situations. And so I think that mediation has a very major role to play there. There's plenty of cases in the courts. There's plenty of cases on the dockets of the appellate division. The law will continue to progress. The jurisprudence will continue to grow. That's not an area that I think I'm worried about.
May I speak to that?
Yes, certainly, Mark.
Judge Graffio and Judge Moskowitz play in the major leagues. I play in the minor leagues. And the cases I see, for the most part, are small amounts of money where the cost of litigation runs up against what the value of the case is. When I started trying cases 100 years ago, doctors would come to the courthouse, $750,000. So if you had a $25,000 case, it wasn't prohibitive. For an orthopedic surgeon in Albany, New York, first of all, they won't come to the courthouse anymore. You videotape them in their office at 7 o'clock when everybody's exhausted, and by 9:30, half the parties are asleep. And then you play a videotape. Now, in America, people look at television screens. Every 7 minutes, there's a commercial, so you can get up and get a beer or a ham sandwich. To ask a 6 or 8 jurors to watch a videotape for an hour and a half, in my experience, if at least 1 or 2 fall asleep, it's awful. At least
Especially
from,
when the lights go down.
yeah, the lights go down, you've been in the courtroom for a week, and they start playing this video, and you see this deer in the headlights physician. How much did you charge? $10,000, and you can hear the air being sucked out of the room. Well, if you have the doctor, then you have a vocational rehabilitation expert, you have an economist because there's a lost wage component. By the time you get done, it can be $40,000, $50,000, $60,000 in a small case. Now, if you have a firm with a lot of cases, you're talking about carrying a big nut on your books. And if you have a case that's only worth, and I'm saying only, to the litigants it's everything, but if it's worth $75,000 and the lawyer takes a third, you can see what the economics are. So as Judge Graffio said, it's in large measure driven by money. That's your opportunity. That's where we started our practice. None of us in my group, it was a group, it's really 4 individuals now, were judges. We're all trial lawyers in a day when lawyers had more opportunities to get trial experience and knew which chair to sit in. But my point is that, you know, if it's complex commercial litigation, that's may not be a point from which you embark. You may want to start where we started, which was small cases where the lawyers are looking for somebody to help resolve the case, either by arbitration or mediation, because they simply can't afford to go to trial. And they can tell their clients, look, if we go to trial, everybody's going to get paid but you, and you're the one who was hurt, or you're the one who lost the money in the contract. So there are opportunities, and that's what I see. I mean, today I had a case I settled for over $1 million, but Monday it was about $75,000. Those are the cases where you can get experience as a young lawyer or somebody who has been around and has some experience to, again, talk what you know, get an area of expertise, as Judge D'Agostino said, get good at whatever you do, because it's a small town, people know. And then market it like crazy. There is no reason in the world why there shouldn't be women doing what we're doing right now. You just have to have the motivation to sell yourself. Now, I could never do what Judge Graffio does and Judge Levine, where they're doing these complex commercial litigation. I would say, you know, you need to talk to Judge Graffio, because it's way out of my league. But that doesn't mean you can't keep yourself busy and charge a pretty sweet hourly rate and make a living doing it. And it's fun.
Thank you, Mark. I've been handed a card that I should plug Albany Law School's semester-long labor arbitration course. So those of you interested in that area of law, we do right here in the school offer a course. So now back to the questions. What have the courts, especially the Court of Appeals, said about mandatory arbitration as a condition of employment? Anybody know?
Well, that's,
I honestly don't know what the court's latest pronouncement on that is. I'm trying to remember. There's
I think,
probably a
isn't
professor
that up-
here who's.
Isn't that issue right before the Supreme Court now?
Yeah,
It is.
well, questions of.
It is.
That issue is an open issue. There's two cases that we're all waiting for to hear.
Yeah, I mean, some sides believe that mandatory arbitration is very bad for consumers and good for corporations, and that is the discussion that's being had. So it is before the United States Supreme Court. I can't remember the name of the case, but it's there.
Yeah,
And
and
there's quite a few challenges to consumer arbitration clauses.
and then there's sexual harassment, which is another topic that is before the state legislature now, and that is whether to allow sexual harassment arbitration clauses. So stay tuned on both counts, I
Right, and
guess.
also there's, one of the cases involves mandatory arbitration in employment,
Which is
setting
pretty
aside
common.
the harassment
common.
issue. Just whether, that's the issue of class actions. There's an interplay of class actions, which in effect are prohibited if you have to go to arbitration. But, but there's a right, there's a labor right to have a class action. It's part of labor law, and that comes right up against the FAA and mandatory arbitration. I know about it because I wrote a decision in which the Supreme Court's going to go the other way. So anyway.
Well, yeah, so there are a lot of competing rights
Right.
out there and a lot of litigation. Stay tuned. Good question. I don't know about this one. It says, for Judge D'Agostino, what secrets, quote, do counsel tell mediators? Well, obviously, you can't divulge the actual secrets, but perhaps what they're getting at is what types of secrets are they?
Oh, yeah, I mean, that's not difficult. You know, everybody representing a client has, you know your case intimately, and you know that there might be weaknesses in your own case, and you also might know something about the other side that the attorney for the other side might not even know. So when I say talking to a mediator about secrets, I mean, as an example, I could be a defense lawyer, which I was, and say to the mediator, I want to tell you something that I need held confidential. The plaintiff claims that he's, housebound and bedbound and can't do anything. We have videotape of him working on his second home up in the Adirondacks, and plaintiff's counsel never served a demand for us on surveillance video, so we have it, and that's why I'm coming in pretty low here with what I'm offering. Please don't share that with plaintiff's counsel. That's the kind of secret that I'm talking about. Or just simply saying to a mediator, look, I don't want to waste your time. I have $300,000. I don't have a penny more. I'm counting on you to do what you do best. But as long as I'm here all day, if I'm here all week, I don't have anything more than $300,000. And I really have to trust somebody to tell them that, because otherwise we play the cat and the mouse game, right? Oh, the demand is $950. Well, I have $120. Okay, now the demand's $840. Well, I have, $190. So if I had a really good mediator when I was practicing, and I really trusted that mediator, I might just say, look, there's something I know that you don't know, and I don't even think the other lawyer knows, and here it is. Please don't, convey that. And that's what I mean about trust. We really need to have a lot of faith in you that you're going to keep our confidences. And that happens with both plaintiffs and defendants' lawyers.
Okay, yeah, sure. Judge Graffian.
Yeah, I think Judge D'Agostino hit the nail on the head when she said it, it's the bottom line. They're going to share the bottom line with you, but they're not going to tell the other side what their bottom line is. But the other thing is, in a lot of litigation, counsel fees are not recoverable. I don't care what kind of case you're mediating. The lawyer's thinking about, am I going to get paid, and how am I going to get paid? So, you know, an attorney may say to me, I've got $87,000 into this case and another 20 in disbursements. I know right off the bat, we've got to get into the six figures in the discussion. If the other side is still putting 40 grand on the table, we're in trouble. Because, you know, this lawyer wants to earn a living. You know, this isn't volunteer work. So they're going to give you certain information about damages and counsel fees and what they feel their client will settle for. And very frequently, because I meet with the parties and their attorneys, but I also I spend a lot of time just with the lawyers. And the lawyers will say to me, I need you to help me with my client. You know, my client still has this problem. I think that the latest offer is getting real close to where we should resolve this, but my client's worried about X, Y, Z. So it's not only confidential information from the client, but also from the lawyer. So, you know, you're trying to satisfy the different personalities.
You know what I think the best thing is about mediators? Mediators get to say things that judges may be thinking, but we can't say. Like, what you talking about, you know? Or, are you serious? That's your demand? I mean, judges, we can't say that. We can think it, but once a mediator has gained the confidence of the parties and the attorneys, I think a mediator can say something like that. I have to say, you are not even in the ballpark of what this case may be worth. So let's break it down a little bit. But judges can't say that kind of thing.
Right. That's called the evaluative stage
Yeah.
of the mediation, where
I'm gonna
after you
move on
hear
to
everything and you're trying to get the parties to resolve it, and they're going, and this way, if you as a mediator can say, well, based on my experience, and this is where we should be, right? Or this is my figure, and that's based on your experience. And you have to be, as a woman, I think it's harder for you to project that than a man. Or you can project it, but it's harder for them to accept it.
Yeah, no, it's the vestiges of implicit bias, I guess. And,
Yes.
would mediation be effective in divorce custody? Now, I know my panelists, and none of you are former family court judges. So unless anybody wants to address this, I guess I'll do
Well,
my best.
Oh,
because
I
I'm
sat in a
acting-
matrimonial part for a
Yeah, I
while.
was an acting
So,
family court,
I
but
mean,
go
we
ahead.
both
I
can
mean, if you
answer
want
it.
to,
Well, the problem with mediation in family situations is you often have unequal parties.
Well, I was going to get to that, domestic violence, you know.
No, you
not-
don't, you can't in
no,
domestic
it's
violence.
right, you just don't mediate that. But other than that,
Other than that, you're still going to have unequal parties. Many times you have excuse me, but it's often the husband who is moneyed, who's experienced, and has been extremely strong with a lot of opinions, and the wife is not. And even when you have lawyers, unless the wife and her lawyer can actually equal that playing field, I think mediation is very difficult in family situations. I
not
really
in-
do.
not
Although
impossible,
I'm going
and
to
in
try it,
support,
though.
yeah.
Because I did sit in the matrimonial part. I had matrimonial cases, and there is a need in family, at least in New York City, in family court. So I'm going to see if, knowing all that, whether these cases can be solved by a mediator without getting paid.
all right, I see, we have a number of judges in the audience, and I didn't want to introduce all of them, but I'm wondering, Judge Fisher, and I'm so sorry to put you on the spot, if you, sitting in Supreme, handling some matrimonials, do you see a need?
There's definitely a need. And I'm a little different in that I sit and read, and I do tend sometimes to have a little more time and more patience than my other, I hate to say this, male colleagues on the bench to study the matrimonials. And I do try to work with the attorneys and settle them, and I do try to bring the parties in and let them know. And I'm very straightforward. I don't sugarcoat anything. I said, listen, for whatever reason, your marriage didn't work out, and you two want to split up, you want to go separate ways, but I think we can agree that I've known you for 5 minutes and you knew each other for 20 years. The two of you might be better at coming up with a solution to your problem than having me, who doesn't know you, make your decisions for you, how you're going to divide up your assets and your most valuable asset, the children, and that usually gets the emotions going. But I do think that, though, sometimes when you talk about the empowerment issue, perhaps with the male is coming, and I had this actually just the other day with a gentleman who was really trying to stiff his wife out of everything, didn't want to give her anything, and she was very meek and mild, and she had a woman attorney who was trying to, steer her the right way, and I just said to myself, to the attorney for the husband, I'm like, does he realize that there's a woman sitting up here that's going to decide this case? And it's not going to go very well for him, given the fact that he's trying to do this to his, spouse. So I do think part of it helps when there's a woman, I think, on the bench. I mean, don't you find that when you have some of these men who are insecure, they're used to railroading their wife or overpowering or domestic violence or whatever the whole power issue might be, that there's a woman up there saying, this isn't going to happen. You're going to get a fair shot in my court. And if I see that, like in this case when the parties came in, I said to them, if you can't resolve it, I am more than happy to decide what's going to happen with all of your assets. And please be advised that I have the power to force you to sell your marital residence, and I'm straight up with them, so they realize, you're not going to, there's laws in place. She's going to get her 50% of that pension. She's going to get, whatever she's entitled to under the law. Do you find that as well?
I find, I'm sitting in a domestic violence part, I never do mediation at all. But when I am in family court and I have parties coming in, and I'll say, would you like to go to mediation? If they're unrepresented and it's strictly an issue of access or custody for the children, I'll often say, the same language. I don't know you. This is, again, your life. I would think you want some control over what the decision is. If you can't decide it, I will do that because that's my job. But I'd like to give you an opportunity to work, see if you can come to that yourself. You can have, and then they come back. I get a report. If they made their own decision and they're happy with it, great. But at that time that they're not ready to make that commitment, again, then they lawyer up and we go from there.
Yeah, I think we're very fortunate to have some very experienced judges in the audience, but I have to remind myself that there are people webcasting, and for those people who couldn't hear what was said, I will distill it into, yes, in the appropriate case, mediation is worthwhile in matrimonial cases, but it's quite often up to the judge, and a woman judge can bring a different perspective, and that's what I'm hearing. It's up to the judge to, first of all, know when to encourage it. If you've got a bully and a meek person, you've got to know when to encourage it and how to encourage it. So that's distilling all of the words of wisdom from the judges in the audience. This is interesting. How are mediators and arbitrators covered, and by whom, with respect to malpractice claims? And I guess that's a difficult question. You've got to be with a firm, basically, don't you, in order to have that.
If you're a practicing lawyer, you better have an errors and omissions policy.
Yeah. Otherwise, you're going to have to buy your own.
Well, NAM actually has a policy.
Well, yeah, or with a firm or with a
Right,
major
and which
provider.
covers it's all the mediators and arbitrators. I read it, and
It's a very good question,
Yes.
something we would all need if we're going into that.
except that as a mediator or arbitrator, you're not acting as a lawyer, right? And so you should, and also the party signed something before which recognizes that you're not acting as a lawyer.
Right.
So
But-
there's
But
two things.
I take it it's the consensus that you shouldn't go out there with nothing. You have to have some protection. No?
My understanding, I make it clear that I'm not a representative of any of the parties.
Right.
They either have their lawyers or they're pro se, but that's rare for me. But certainly, you want to be covered by a malpractice errors and omissions policy when you're a lawyer and you're doing anything other than going to the grocery store, because it's crazy not to.
Yeah, sadly, that's true. Okay, after graduating from law school, is it realistic for someone to become a mediator right off, or an arbitrator right away? I don't, I'll just answer that quickly if I may, and I assume that everyone would agree. You're not going to get much paid work right out of law school, even if you've taken the very good courses that are offered at this particular law school. I think you need to get your feet wet by volunteering if you're right out of law school initially. Is that the consensus of the panel?
Yes.
Okay.
I think it goes back to what-
And/or litigating in a particular practice area first, developing an expertise in that, and then becoming a mediator or arbitrator.
I was going to comment, dovetailing back to what Judge D'Agostino said, get good at what you do, but that takes time.
And this question is for Judge D'Agostino. I'm a member of the Northern District Mediation Panel, but I've only been asked to mediate 4 or 5 times.
I was waiting for that. We have some fabulous attorneys on our mediation panel, but what I see anecdotally, without even keeping any statistics, is that there are 3 or 4 individuals who are persistently contacted because of their reputations, word of mouth, how good they are at settling cases. And of course, the magistrate judges can assign a mediator in the mandatory program, but when it's voluntary, people will often go with a known quantity. And I see the same group of mediators being used very frequently in Albany, and I wouldn't be surprised if that isn't the case in Syracuse as well. I think that the only way practically to handle that is for practitioners to, again, speak to their clients and their corporate clients and to talk about diversity. We have, like, retired Magistrate Judge Treese here in Albany, retired Magistrate Judge Homer, and a couple other practitioners. They seem to be the go-to people for mediations. And it's not going to change overnight. And people like Mark and Jim Hacker and the others, the reason that people are calling them is because of the fact that they do a good job. And Judge Graffio, they know that they're a known quantity. They know how effective they are. So the only way slowly is to have other people get some of that work, I think, is through practitioners talking to their clients about diversity. It has to start really in a grassroots setting, and diversity should be a part of the discussion. But I was waiting for that question because I'm very aware that people are going to the same mediators very frequently.
I thank you. I'm just hoping to raise awareness, not just with this program, but we've been drafting articles. This is an issue of interest to our committee. And that, again, I don't think anybody is intentionally discriminating. They just need to start thinking about diversity, and I'm really hoping that that will come out of this program. Now, I have to break now because we have gone too long on the first segment. And not only that, I was silly enough to put this cookie in front of me, and it's been I've been smelling it throughout this. So we all need a break, and I need to eat my cookie. I'll see you in 10 minutes. Oh, and John Carr has been sitting here in front of me all this while, and I thank the committee as a whole, but I have to give a special thanks to this guy who is involved in every aspect of the planning, the promotion, the webcasting, and now he's even our photographer. So a special thanks to John Carr, as always, and to Patty Beeler, who arranged for all those goodies that you're about to partake.
To find a
Okay,
restroom.
see you in 10.
Oh, this one might
Let me know. Okay. All right, welcome back, everyone. And first, I have to start with a housekeeping measure. As you know, we're being webcast, and that means I have to give the code. And the code is 24601 for those participating remotely, 24601. And that's also a test of your literary acumen. And I'll just do quickly. Anyone know the significance of that number? No Victor Hugo fans here. Les Miserables? That was Jean Valjean's convict number. Just a little. Okay, so.
I learned something new today. That's right.
Thank you. So far, we've discussed the what, the why, and the how. You know, how do you qualify is the how. And so I'm going to move right on to ethics. And Mark, I'm going to start with you because I know you've talked about ethics and ADR in other CLE programs. And so I'd love to get an overview from you and then see whether our panelists have any ethical conundrums that they might have experienced or that they witnessed. So take it away.
Sure. They always leave ethics for the last. Usually on a nice spring day, it isn't so nice out. And the reason is because all the lawyers need that ethical point to fill their clinical legal education program. So I'm used to going last on nice days when nobody wants to be around and they're stuck with ethics. So I'll try to make the most of it.
They're not here.
Sorry. You can skip that part anyway. To me, the most frequent issue is, truth-telling versus hyperbole. Is the lawyer puffing? Is it unethical to say, I won't take anything less than 300 when you know darn well that the irreducible demand is reducible, and as a mediator, you know the immovable offer is movable. But I'd like to defer that. That's the most common issue as far as ethics. But I'd like to maybe start with an example of a situation I confronted. And the question I'll put to everybody is, what rule of the New York Rules of Professional Conduct, which govern our behavior, didn't this violate? Yeah. So I'm in the middle of a mediation. It's getting toward the end. I think of the mediations I do as divided into 3 sections. The first is the posturing, sort of like 2 boxers in a ring and they're touching gloves and they're dancing around each other and nobody's really doing anything. Where the plaintiff is usually way out of the ballpark and the defendant is offering something that's also out of the ballpark. The metaphor I used to use is we can't start the music until everybody comes to Roseland, and if nobody's in the dance hall, we're not going to get anything done. But that's phase 1. Phase 2, I like to refer to as fulcrum finding, and I'll take objections from anybody who has a different view of this. But phase 2 of the 3-phase view of mediations is fulcrum finding. Like on a teeter-totter where you're looking for the middle ground, everybody is offering and demanding because they're doing the math in their heads about what the middle number is going to be. And then the cleanup phase, phase 3, is usually bridging the gap. One's at 150, one's at 160. How about 155? Some third-grade math comes in at that point. So I'm conducting a mediation. It was down in the Hudson Valley. And we're going along, and it was a personal injury case. Just by way of background, it involved a man who had a green card. He had a thick accent. He had set up a business as a taxi cab driver. And he filed income tax returns that were considerably at variance with the records that he was presenting to show his lost earnings. So he was suing for pain and suffering and for lost earnings, and there was a very considerable discrepancy between the records that he said he kept, which were, handwritten notes on a spiral notebook, and his filed tax returns. So we're going back and forth, and I caucus the plaintiff and the defendant in these cases. That means we have a brief meeting in the beginning. I tell them what the ground rules are. I talk to them about confidentiality, about how I'm going to present offers and demands, a few devil's advocacy, a few other issues, and then I separate them. So I'm walking back and forth in the room, and we're getting close. Now, the insurance person wasn't there. It was a young lawyer from a downstate firm, and he was making telephone calls to the insurance company every round in order to get some more money. And as we got close, I came back with a revised demand, and the young lawyer looked at me and he said, I just talked to the adjuster. He said he has this is his figure, and if the plaintiff doesn't take it, he's going to report him to the IRS. So the question is, what rule of professional conduct didn't that violate? Because there's a whole bunch of them. You can't bribe people to settle a case. If those of you who are students are closer to ethics courses than us old lawyers who haven't seen the bar in 40-something years, but it's Rule 3.4, fairness to the opposing counsel, fairness to the party. You can't present or threaten to present some criminal charge in order to shake somebody down. Lawyers are supposed to respect their opponents. What else? I lost track here. And you can't, it's really fraudulent and it's dishonest. So I was kind of taken back, and I looked at the young lawyer and I said to him, you don't really want to go there. Your adjuster is really asking you to violate the canons of ethics. Now, my conundrum was, do I tell the opposing lawyer that this happened? On the one hand, I don't want to be a participant in this bad behavior. On the other hand, he may have another lawsuit, and he may want to know. And so that was the horns of my dilemma. Anybody have any thoughts? I'll throw it out. Then I'll tell you what I did. Hi.
The attorney who suggested the unethical response withdrew it, does that then solve the problem?
Probably, but he didn't.
He stood by his position.
He didn't know what to do.
Okay.
He was flummoxed. And of course he had to speak to his masters, this person behind the curtain who was at the insurance company someplace in Long Island, who thought he had come upon a way to settle the case. So I pointed out to him that he was barking up the wrong tree. He didn't like it, but he didn't know what to do. So I went to the other lawyer, and I said, this is what just happened. And I told him, I said, but he can't go there, and you know it, so why don't we just continue as if it's a normal offer, and you respond. So they didn't take it, and then I went back to the defense lawyer, and I said, this is their demand, and your guy has really put himself in a terrible position and probably compromised his negotiating position. And by the way, if you do something like that, the settlement can fail because you have this fraudulent behavior going on. And they eventually settled it for more than that number, and I never heard from it again. But I thought it presented an interesting conundrum, not only for me, but for the lawyers involved. I think if I had a more seasoned a stronger defense lawyer, he would have not even mentioned it. He would have said to his client or his principal in this case, I can't do that. But he didn't know that. So that was, I don't know how other people would handle it. I was actually so taken back. I didn't know what to do myself. And I was really torn about whether to say it or not, but I thought I was duty-bound to tell the other side that this had happened and, give him the options of how to respond to it.
Rachel?
Do you want to?
I don't want to comment on that, but I want to say something else about ethics.
Please, Judge D'Agostino.
That sounds like a tough situation. But one thing that I want to say about ethics and becoming a mediator is that as you embark on this path to try to get involved in mediation and arbitration, try to be very honest about your own resume and your own credentials. And I say that because when I was practicing, I would get resumes from people, and I felt that some people were not being totally above board about their experience. So it will happen for you, but don't hyperbolize on your resume. I've gotten resumes when I was in private practice from people who say things like, I have litigated scores of cases. Now, I practiced for 30 years, and I did try a lot of cases, and I kept track of them. And so when I was interviewing them, I would say, you've litigated scores of cases, and it was painful like that, hearing that we all saw on TV when somebody was trying to be a federal judge, like how many depositions have you taken? Well, I can't remember. More than 20? No, not more than 20. So I'm just, as you embark on the path, just be completely honest about your credentials. And the best thing you can put on your resume ethically is all of the training that you've taken. That will be eye-popping. That will catch somebody's eye. But don't talk about scores and dozens, and be careful about litigation. Litigation means different things to different people. Litigation for me means that you have had depositions, that you have gone to pretrial conferences, that you have written motions for summary judgment. That's one thing I want to say. Good things will happen to you if you're honest. You don't have to hyperbolize. And the other thing is the ethics of not being too eager to be a mediator if you have a conflict. Because I have had people in federal court come to me as a judge and ask me to vacate a mediation or an arbitration because post-mediation or arbitration, something has been divulged about the mediator that was not known. So for me, ethics involves honesty in everything that you do, particularly when you're applying to be a mediator. And secondly, don't be so eager that if you do have a conflict, and Judge, you can probably speak to this, don't get involved in a mediation when you have a conflict. Always err on the side of caution. If there's even an appearance of impropriety for you serving as a mediator, the next one will come. That's all I wanted to say.
Conflicts is a very important issue for arbitrators and mediators. So
There's no case that I will take without running a conflict check in the office. So the first thing when somebody calls my office or sends me an email requesting a mediation or an arbitration is, please send the full case caption, the venue, and the index number. And then we circulate it and make sure that there are no conflicts before we even embark on scheduling.
Yeah, and before I turn it over to Judge Grappio to expand on that, I do want to say, with regard to the honesty on the resume, this, I can't emphasize enough, this is a very small town. And everybody gets to know everybody. So you've got to start out by being honest, really, if you're going to plan on staying here. Go ahead. Conflicts.
Oh, Yeah, I'm going to address arbitration first and then mediation. Whether you go to training as a mediator or in arbitration, a very substantial portion of the training deals with disclosures, 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 because that's a grounds, especially in arbitration. Bias is one of the very few grounds for setting aside an arbitrator's decision. So the difficulty, especially under the FAA Code of Arbitrators, and also I'm sure NAM has a code, and AAA has a code. All these organizations have codes of conduct for mediators and arbitrators. Particularly in arbitration, the conflict check is not just the parties. You know, I'm in a law firm with over 200 lawyers. We have a computerized, sophisticated conflict check system, but it only checks parties. It doesn't keep track of the names of the law firms and the individual lawyers who represented those parties. So, for instance, end of last week, I had to send an email to over 200 attorneys indicating the names of 2 attorneys that have asked me to be an arbitrator, and I have to find out if anybody in my firm has had a previous case with either one of those attorneys, or if we have a current matter involving one of those attorneys. And I found out that one of those lawyers had been employed about 12 years earlier at my law firm, which obviously he knew, but I'm not so sure the other attorney knew. So the disclosures can be very time-consuming, and especially in arbitration, there's forms that you will be sent. There's like a 6-page form by AAA. You have to indicate if any member of your family knows any of the witnesses, because they'll give you a witness list, so you have to do conflicts check with the witnesses, not just the attorneys and the law firms. It's a tedious practice, but the reason behind it is because you want to preserve the integrity of the arbitration decision. And so the arbitrator has to be, absolutely pristine in terms of any kind of self-interest in that particular case. Which gets difficult. I will say it's a lot easier to do arbitration if you are not with a large firm. There's a lot of conflicts that come up. Probably 1 out of every 3 requests I get for mediation or arbitration, I have to decline because I have a conflict within my firm, not so much me, but because of the nature of all the cases and the fact that we represent a lot of banks and a lot of insurance companies.
I have to ask you a question before I let you move on. You have to decline, you said, but we as judges, we just disclose and sometimes let the parties decide, do they still want us to preside, even if we know this one or that one or whatever?
Well, it depends on the nature of the conflict. Sometimes, for instance, in this situation where one of the attorneys had worked in the firm, the other lawyer waived that conflict because he knew that the employment had been many years earlier and I wasn't even a member of the firm at that time. However, if somebody's asking me to do a mediation and it involves an entity that we are suing or representing, if we're representing that party, maybe they'll waive that conflict, but chances are the other side's not going to be comfortable with it. They're not going to waive it. If we are suing that entity, then that's almost, pro forma, I am not. It's a bias situation, so I decline it. It's not worth getting into that because our client could be upset. So you sometimes have a business reason. If not a direct conflict, there can be what I call a business conflict. The firm doesn't want to be in that position, explaining to that client why we do a certain thing. We do a great deal of asbestos defense work, so we have a business rule. I do not do mediation or arbitration that involves asbestos claims. It's just, it's a business conflict for us. We represent too many insurance companies in that field. So the larger the entity you work with, the ethics become a little more critical. For mediation, there's also, of course, an obligation to disclose. But I think in mediation, what becomes equally important is confidentiality. That's it. That's a huge part of mediation. I will always ask the attorneys, if they want their pre-mediation reports back, people will put medical records, they will put financial records, they will put all kinds of personal information in the exhibits that they send to me because they are confidential to the mediator. And I will always ask if they want this back, because chances are they don't want it floating around in my office. And I will indicate that if they don't ask for it back in 90 days, it's right in my mediation letter that I will destroy whatever they send me, because I don't want to be responsible for that information getting out somehow. So confidentiality is a very major part of mediation. I have, and I think most mediators have in their engagement letters, that we will not be subpoenaed and we will not testify on behalf of any party in future litigation. So again, that's to protect that what the parties tell me remains confidential and is not able to be disclosed. However, there are some court challenges to that. There's a recent case on Law 360 involving a law firm in New York City, and they are looking for the mediator's notes.
Yes.
So that's another reason why I destroy everything after 90 days. It's better not to have anything in terms of this. So when you go to the training for mediation or arbitration, there's just a whole plethora of these ethics rules that will kind of be pounded into you so that you're very aware. So that bias and confidentiality, I would say, are the two primary ethical considerations. Misrepresentations is the third. You don't want to claim that you know something, or that you go in and you misrepresent to the other side what the offer is. Like, you think you can get them up to 175, but they're only at 150, so you go in the other room and you say, well, I have an offer of 175. You don't want to do that. That's misrepresenting where the other party is. You do that and lawyers are not going to trust you. You can't come to your own resolution. You are just a mouthpiece for the parties. You're trying to facilitate their constructive and productive discussions. You're not the decision maker. That's a hard thing for former judges to do in mediation, by the way. I'm sure Judge Moskowitz has experienced that. I can't tell you how many times I'll go in my office during a break and I'll think, if I were still on Supreme Court, I could tell these people what this case is going to settle for. But you're not supposed to do that as a mediator. So it's a more time-consuming process to bring people to that point of recognition.
Anybody else? Okay, Mark, you have more things on your outline that I saw, your ethics outline, than those three. But those are the key. Those really are the key ethical issues. And have any of you do you have case examples that you can think of? I don't mean to put you on the spot, but off the top of your head, that illustrate these very important points.
Well, I have a question to throw out. This hasn't happened to me, but what if you do your conflicts checks, everything is fine, and then it's a long arbitration, and in the middle of the arbitration, your firm takes on a case, gets involved with one of the parties. What is your obligation at that point if you don't know about it, or if you do know about it?
The AAA rules require that your disclosures not only are pre-arbitration, but during the course of the arbitration. And what can happen even more frequently than that situation is where all of a sudden, if you're going to be an arbitrator, you always want to ask for the witness list ahead of time, because you also have to do a conflict check on the witnesses. You have to indicate if you know any of the witnesses, and AAA will ask you, does any member of your family know any of the witnesses? Has any member of your family ever sat on an organization where one of the witnesses have been involved? There's all these relationship questions. So if all of a sudden in an arbitration one of the parties presents a witness, and you realize that you've had some relationship, you've served on a board, this person lives down the street from you, something of that nature, you have a continuing obligation to disclose, and then the parties have to decide. If they don't want to waive that, then that's the end of the arbitration, and they're going to have to start again, and I presume you probably are not going to get paid for what you've done up to that point in time. It's a disqualification.
Well, what if it's the law firm and no one tells you? And then afterwards, after the arbitration is over, that's a ground that's made, it's a contention that's made that there was a conflict created by the law firm during the arbitration.
I think they can probably bring an action to set aside the arbitration
I
decision.
think it would be vacated, and I
Yeah.
think you would have to put your malpractice carrier on notice
Yep.
ASAP, because one hallway of the firm needs to know what the other hallway is doing. I mean, yeah.
That's why I said the larger the organization you work with, it's a bit of a larger headache. You know, you get different types of cases, maybe larger cases come in, but the offset for that is that there's a lot more conflict and ethical considerations. You find, especially in New York City, a lot of the folks that do mediation more or less are sole practitioners, many of them. When you go to the trainings in New York, you know, they work out of their house, a lot of them, and that way they avoid all conflicts. Or a lot of people work for NAM and JAMS full-time so that they avoid the conflicts because they're not in law firms. So there's different ways to approach this. I think as ADR becomes more popular in the Capital District, there may be opportunities for people to do ADR exclusively in small group practices, and this way they'll avoid some of the conflict restrictions.
I think sometimes other ethical issues come up, and I haven't mediated in a while, but I just give this example. Like if you're a mediator and you've worked out a number and an infant is involved. I mean, last year I was trying to settle an infant case, and I arrived at the number I was a judge, not a mediator, of course, but I was kind of acting as a mediator, and I got everybody on board. And I hear like a husband whisper to the wife, well, now we can put that addition on the house. And I'm dealing with a 14-year-old boy here. So, I mean, you can't hide from these issues when you're a mediator, just as you can't hide from them when you're a judge. And I was like, okay, we're going to take a time out here. And I had the youngster step out. And I made it very clear to the parents that this money was not for an addition to their house. I mean, crazy things happen during a mediation, and I think you have to stop and you have to fix them. I've also had issues where I've almost questioned the ethics of an attorney who's talking to me more about attorney's fees than what's going to go into the pocket of the client. And I think that that's a little bit more difficult because you can't practice law, but when an attorney is more interested in a mediation in what their fee is going to be as opposed to what's going to go into the pocket of the client, I think that has to be addressed too. And that happens, I think, with some frequency. I had a case in Syracuse where there was $250,000 on the table. And I said to the plaintiff's lawyer, you better take this and run. You're going to get zero from this jury. And she said, but Judge, my fees are thrice that. I went, really? And she said that on the record. So I said, well, are you interested in thrice your fees, or are you interested in getting $250,000 in your client's pocket? She wouldn't settle. I said, I want you to go on the record and tell me that you have told your client that that money is on the table. And she did, and we took a verdict, and it was zero. So sometimes the lawyers drive you absolutely crazy when you're trying to settle stuff.
I should mention, because the judge raises a very apt point, Mediation can also involve structured settlements, infant settlements, a special needs trust, depending if you're doing large dollar personal injury mediation, those tools are also available. And to a large extent, if you know you have that kind of mediation, you can ask for a representative from one of these companies that does structured settlements to be there. The lawyers generally have some idea, and this is part of the pre-mediation conferences that you have with the attorneys. Is this going to be the type of case that's going to need a structured settlement? Okay, well, let's make sure we have the right insurance representative here who can run the numbers and keep giving the plaintiff the payouts so that they have some idea of what they're agreeing to. That's very important. So it may not be as formalized as what would occur in a courtroom, but there's still those tools available.
I had that this morning, and it settled the case. Generally speaking, the plaintiff's attorneys want to know what the dollar figure is and what the cost of the structure is going to be before they'll agree to it. But we had a plaintiff who was a very unsophisticated person, and the structure, in my mind, was more significant not to stretch the dollars, but to make sure that when this person who couldn't work anymore doesn't go out and buy a Corvette and wrap it around a tree. And I've had that. So what I do is at the end of the mediation, and this was this morning, I have a settlement agreement because I'm a congenital optimist. I walk into all these thinking I'm going to settle them. And I have a standard forms settlement agreement, and they can either cross out or add on, but it deals with liens, adverse interests, things like workers. Sometimes the gorilla in the room is the workers' compensation lien, which is, by the time you get done with the comp lien and you get done with the lawyer's fees, you got to make sure there's enough left.
Medicaid liens.
Medicaid liens, collateral sources, all the kinds of stuff that can go on before you can get rid of a case. Medicare, Medicaid, the list goes on. It's complex. So
That's part of the ethical obligation of a lawyer, too, if you're involved in mediation or arbitration. You have an obligation to understand what liens may come out of your client's recovery. Oftentimes, a lawyer will come in and say, well, I think there's a Medicaid lien. I'll say, well, how much? And have you discussed whether they're willing to negotiate that lien? And they'll say, well, that's not my problem. Well, yes, it is your problem, because you're making a recommendation to that client. So if that's a situation that can be involved in any of my mediations, that's something I deal with before the mediation session. I want to know the extent of the lien, and I want the lawyer to have a discussion with DSS. Yes,
By the way,
Dana?
Isn't there an ethical obligation for the attorney for the plaintiff to set aside sufficient money for the Medicare lien? And if they don't, aren't they ultimately responsible for that Medicare?
I think a lot of people don't recognize that don't handle it frequently.
my experience is that the insurance company won't issue the check until they get a final letter from Medicare, Medicaid. It's part of the deal. So even though the CPLR may require 21 days after submission, you have to check the boxes, but you send the releases, stipulation, discontinuance, you're not going to get a nickel from most of the insurance companies I've dealt with until they get that final letter from.
And that takes sometimes 60 days.
Sometimes it takes longer than that, yeah.
Okay.
Yeah, absolutely.
I just looked at my watch, and we have only about 5 minutes remaining, and I do want to get to questions. I only have one on the index card, but I will open it up after that if we, but the one on the index card is a good one. Have you ever talked to a party in mediation without his or her attorney present?
No, never.
No.
It's unethical. And I tell them that before we even start. I'm sorry, I didn't mean to.
No,
jump
no,
in.
I mean, that's an easy one.
That's
So I
real
wanted,
easy.
I wanted to get that
Before,
done.
if I may.
You know, everybody agrees.
I don't want to take too much time, but before I start every mediation, I deal with 4 issues. I bring the parties together, and it's my custom and practice to then caucus everybody. So I shuffle between the rooms. But I always talk to them about patience. It's a process. You're not going to get the offer you expect in the first round or the second round. It's going to take time. Prepare them for it so they don't get all upset when they're disappointed with the offers. 2, I talk to them about being a devil's advocate. If I tell plaintiff you have a great case and then I tell the defendant you have a great case, we're not going to get anywhere. 3, I talk about confidentiality of communication. Be very clear with me about what you want me to carry to the other side. I don't want to do any harm to your negotiating process. So confidentiality to me also includes not only substantive things, like I've got a video of the guy pole vaulting when he says his shoulder wouldn't move, but it's also, you know, making sure that you have the right communication about what the offer or the demand is. And the last thing is, I ask permission from the plaintiffs to speak to their lawyer alone. I learned early on that I knew the lawyer very well, and I said, could I talk to you a second, Dana? And the client went nuts. And it sank the mediations. But I find that if I ask them permission, then they take ownership. But I also tell them, I will never talk to you unless your attorney's present. The reverse doesn't work, because I think that's unethical, it's improper, and you could be criticized for it. So it's 0. I never talk to them without the lawyer.
No. Okay, any other, Dana?
Would it be ethical for one of us here in the audience who was thinking about perhaps making a foray into mediation or arbitration to mentor or apprentice with someone who's currently doing a mediation or arbitration, assuming there's no conflict?
It's
You
funny.
mean attend the mediation session? They have to consent.
Yeah, you would have to get
Parties
written
have to
consent from the clients and from the attorneys in that mediation.
But you know, it's a wonderful thing that you raised that mentoring issue, because I was going to conclude by mentioning a program that Judge Graffio brought to my attention. The New York State Bar Alternative Dispute Resolution Section, if you're a member of the New York State Bar and if you belong to one of the underrepresented classes, e.g. women and minorities, you may take advantage of their mentoring program. And I would think, if I were just starting out as a mediator or arbitrator, that I would want to be with an experienced mentor. And here the service is being made available to you free of charge. So I encourage any of you who are interested to take advantage of that opportunity. Now, is there anything anyone has to add?
Well, I just want to say something very quickly, because I want to get back to the snowstorm. The reason I have to get back to the snowstorm in New York City is I'm going to a course that starts tomorrow morning. It's all day, and it's at Fordham. And, you know, we talk about, we always talk about mediation and arbitration being faster, cheaper, right? And I always forget the third one. But it's faster and cheaper than being in court, right? However, the name of the program I'm going to is Underutilization of Mediation and Arbitration. Is that what is happening right now? Because what has been happening is that, particularly in arbitration, but also mediation, there are now efforts by the parties to have discovery, EBTs, bring in experts into the process. So the cost of the mediation arbitration balloons, and the other cost is the cost to pay the mediators or the arbitrators, which is a cost you don't get in court. So then those are factors that lead to perhaps underutilization of mediation or arbitration. So I'm very curious about this course, because I always thought of mediation expanding so that there are more of us that can be mediators and also in arbitration. But here is something where there's a discussion of, well, is it underutilized so that it's not going to expand. So if you want to, I'll get back to you and tell you what I learned.
I'd like to know. Yes, May?
When Judge Graffio was talking about Medicare liens and liens in general, it got me thinking that one thing that you could add to your resume that might make you very appealable as a mediator is some expertise in that area, because over the course of my career, it became very, very difficult to settle some cases because I didn't quite understand who the lien holder was, what the lien holder was claiming he or she was entitled to. It gets very, very complex. And yes, you can hire experts, and every once in a while there are seminars from the New York State Bar on liens, and you get, the bean counter types who can really talk to you about liens in a way that you can understand. I would think something like that on your resume might make someone take a second look at it, that not only am I familiar with liens from, I was in business before I became a lawyer, or I was a business major and I understand liens. That might get somebody to take a close look at your resume.
Good point. Well, what time is it? It's on the dot, 5:45. And we do actually have to vacate this room because the moot court people are coming in after us at 6 p.m. So I hope that you have all gained valuable insights from this program. I have, and I hope you have as well. Please be sure to fill out your evaluation forms, and please, Mark is not Jim Hacker, so if you could just cross out Jim's name and put Mark's name in instead. Even though they work together, they're not.
Thank you.
Thank you all. Thank the panelists.
You have a safe trip back. Oh, thanks. I really want to take the train.
Like it.
Yeah.